All right. Hello, everyone. This is Colin McCarthy. I'm a partner at Angus & Cherry. We're doing some new manager training today. It's my pleasure to be able to give this presentation to you. It'll cover some basics that should help you as a manager and a new manager understand both what is an association, how you can get some business done both through the board and outside of board meetings, and really give you a framework to kind of hopefully do all the work that you do. This is a caveat, that's a lawyer word for warning, that this is generalized statements about the law. It is not specific legal advice for your specific situation. So if you have a specific situation that you want an answer on, it'd of course be my pleasure or the pleasure of anyone else at Angus & Cherry or any other law firm that you've engaged for these services to give you that advice. So if you do have a specific legal question, by all means, ask an attorney. I certainly would be happy to answer it for you, and I'm sure that there are other people out there also. All right, let me see if I can get to the next page. That didn't work. I can't. Oh. There. Does you see the next page?
Yes.
Yeah. Yes.
All right, super. Thanks. All right. This is us. We're a firm that's specialized in this for 35 years. We do a community association law. We've got clients in California, Ohio, and Florida. And we've been doing not only the general counsel stuff, helping you with your governing documents, helping you interpret them, helping you with contract review, discipline matters, things like that, but we also do the construction defect cases. So if you're having a leaking roof and you're in an under 10, meaning it's only been around for less than 10 years, we can help assist get the defects fixed for your association. So that's what we do, and we've done it for a while. We believe that we're superior. We are certainly responsive. It is one of our, what's the word, kind of marching orders, or no, that's not it. It's not orders. It's a community feel. And our what we want to convey to the community is that we will respond to you. If you give us a question or ask us something, even if we can't get the answer to you right away, we'll acknowledge the outreach and let you know, and we'll do our very best to get it back to you. So we are responsive. We're pretty reasonably priced as far as it goes. And I guess we're running a special now for new associations that sign up for us. All you got to do is sign the agreement. You get a complimentary 60-minute board training, which we'll talk about in a little bit. And the first 6 months of that representation is at the reduced rate of $350 an hour, no matter who is working on it. That's a good deal if you've got a new association that's maybe not behaving or has some legal issues, and you need to get counsel's foot in the door. This is a good way to kind of shape up a board, get them paying attention, and having us do some work at a reduced rate. Okay. This is the disclaimer that I gave you earlier. It's not legal advice, just general information. And if you have specific issues, just let us know. Also, laws do change. So they'll be changing in October or November pretty soon here. So just be aware of that. Okay, so this is going to be about the Open Meeting Act and other legal tools for managing homeowners association. Let's get started. Our world since COVID, it has been wonderful. It's been great. Well, it's been exciting, at least, that we're back out there. But because of COVID, there's more people at home, more people working at home, and you're going to have more complaints. People are angry. They're irritated. They're frustrated because it was a huge upheaval. And not only that, but now things are getting more expensive and there's less money and insurance rates are going up, and repair costs are going up. So there are a lot of issues that are born of COVID or its byproducts that are making your job and ours a little bit more difficult since COVID. And the more complaints you get, of course, the more it costs. The more it costs for you to respond if it's outside your management contract. And if you have to bring in legal, then that costs more money as well. So another thing people complain about is response times. Everybody thinks that you work for them and that if you don't respond to them right away, like that they're the customer and that they're always right and you're wrong and you got to respond right away. Hopefully some of the things in this presentation will set your expectations about that so that we can set their expectations about that. Because really, as I'm about to tell you, this homeowners association is not a business, even though it's a corporation. So it's kind of a little bit of a hybrid, and it operates in a very specific and statutorily prescribed manner. It can only do things in a certain way. And that's what we're going to talk about today. So people need to have their kind of expectations set. Yeah. And this last point is just like our life now everywhere. Everybody's got strong opinions and I'm right and the other side's wrong. And there really isn't any willingness to listen or compromise among everybody. And it's best if we can do our jobs here with a smile and a willingness to compromise, but it isn't always possible. So just realize that that's the kind of environment you're in. And let's give you some context as to what is the homeowners association and how does it work. All right, a homeowners association is, as stated up there, a nonprofit mutual benefit corporation. So there's a couple of things in there, 3 real things that we can glean from that phrase. It's a corporation, right? So there, as a lawyer, that puts a flag up for me, meaning, all right, it's a corporation, so certain corporations codes are going to apply to it. And also we know as lawyers that there's this thing called the Davis-Sterling Act that controls it. That was specifically designed to address homeowners associations. So it is a corporation, but it's a nonprofit one. It's not supposed to make money. It's supposed to benefit the mutual owners of the association, right? So everybody who buys a separate interest, a condominium or a townhome or a residence at that lot is a beneficiary of the homeowners association. They're a member in it and a part owner. And so the association is set up to run that for their benefit. But it's really for everyone's benefit, not just necessarily that specific owner's benefit, but the whole community's benefit. All right. And so how does it do that? It does that with a board of directors like other corporations, right? And so most of the time, and we'll talk about the exceptions, the association's quote unquote business has to be conducted at a meeting of the board, right? So unless it's an emergency or something super time sensitive, these decisions can't be made in between board meetings, right? And the reason for that is that it is there's elections and it's an open meeting, and they want the members to have the ability to attend these meetings and listen to the board's discussions about things that affect their mutually beneficial society. Okay, so once that there's been a communication, from the homeowner to you or the board, we're going to talk about how usually there's no real purpose in further communications to that person until after the next board meeting, right? So we'll talk about that. And the thing that drives that is the Open Meeting Act. He's not really your friend, and it's not really a person, but the Open Meeting Act you should use as a tool to help you manage your owners. By the way, I know this is new managers, and I can't see you right now, so I'm going to take a risk. Nor can I hear you, but I'm going to tell a joke.
You don't want to hear us or see us.
Okay. All right. But I'm going to tell a joke that you probably have heard before, but some of these managers may not have. So just to keep you paying attention. Before we get into the details of the Open Meeting Act, I wonder if anybody has heard about the zoo with only one dog in it. I think some of you have, but many of you have not. And you know what it is? It's a Shih Tzu. All right. I can't.
You're terrible.
I know. I can't tell if it works or not. I just say it. All right. The Open Meeting Act is your friend. Why is it your friend, Colin? Well, because it structures and dictates how the board makes decisions. And it's going to be something that you can tell these complaining homeowners that, look, we cannot do this. The board can't make a decision on that until a board meeting. And so here's the law. It's up on your screen. It's pretty much in the opening salvos of the Davis-Sterling Act. There is a board. The first one is board can't take any action on association business outside of a board meeting. And that's the rule, right? So it's right there. When can you have a board meeting? You got to give notice of that board meeting to everybody in the association at least 4 days before it, per statute. It's possible your bylaws could give you longer, but it can't be any shorter than 4 days. So you have to give notice of the meeting. You have to say what's going to be on the agenda. And in the agenda, that's only the only thing that can be discussed is whatever's on the agenda. So here's an exception. Well, not an exception, a different kind of meeting that can be given on shorter notice is the executive session meeting. And that's to discuss lawsuits, contract, discipline matters for employees or personnel, membership, payment plans, and membership discipline. Those 5 things can be done at an executive session, and that can be done on 2 days' notice rather than 4. And it doesn't have to be as express of notice. It just can say, litigation matter or member discipline, something like that. And it doesn't have to get real specific. Okay. Well, can the board discuss things outside of a meeting? No, they can't. They can't discuss anything at the meeting even unless it was on the agenda that was in the notice that went out at least 4 days beforehand. And that's right there in 4930A. All right. So if it's not on the agenda, you can't discuss it. And that's a pretty good for the people who come in and talk about something that's totally unrelated. That's a good statement to say, look, we'd love to help you with that. But we can't talk about it. We'll make note of it. And it's possible it could be put on the agenda for the next meeting. Thank you for your input on that. But the law doesn't let us discuss that today. And when you think about it, the reason is because there might be another homeowner that issue affects, but they read the notice 4 days before and it said it wasn't on the agenda, so they didn't come to the meeting. And so then they wouldn't, if you start discussing it at the meeting, they would say, well, my due process was not granted me. So the idea is everybody should be on notice of an issue. And if it's in that notice, you are on notice. And finally, I literally just an hour before this meeting, I had a client ask me about there's whether or not they have to have another meeting, and there's a time press on it. And so I was giving them some options, and one of the options I gave them was this 4910B thing. I said, look, it's enough of an issue right now that you couldn't reasonably foresee it. And you need to take some action quickly. You can conduct a meeting via email because I think it's reasonably, unforeseeable that this situation came up, and it wouldn't be practical to give everyone notice. So there's a couple of conditions to that. It's got to be unanimous, that everybody agrees. All the board members have to unanimously agree. And there's some debate about this, but we think that generally speaking, that whatever decisions are made at that meeting also have to be unanimous. So, but it was funny because my clients' governing documents were so old that they said one of the ways that you could do a special meeting was by telegram, and it did not it did not have email as an option even in their bylaws. But I was able to cite to this 4910 and say, hey, the law says you could do it this way. So,
Hey, Colin, Davis Sterling website just sent out a newsletter about that topic. I don't know if you subscribe. They were saying that you don't need quorum for the, or what do you call it? Everybody to agree for the topic. It's a quorum. But you guys, I know how you guys may disagree.
yeah, I think that I agree that it has to be unanimous, that everybody agrees that we're going to discuss that topic, right? And that we all agree, okay, we can have a meeting about it. And that has to be in writing, and you have to put that at the next minutes. The issue is, does the actual decision that's made have to be unanimous? And I'd love to see that if they comment on that, because the more input, the better. Me and Ann were just discussing this the other day, because sometimes you have situations where there's a conflicted, I've had a situation where there's a conflicted board member, and we had to get a potential emergency meeting on, and you weren't going to have quorum. So the issue was whether or not we could do it without the full board if they started the meeting and then left the meeting. And I think we decided it was possible in that situation, but again, yeah, it's open to discussion. Could you forward that to me?
Sure.
That's awesome. Thanks. All right. Emergency board meetings. As I was just kind of talking about some of the basis for that. An emergency board meeting may be called by the president of the association or any two directors if there are circumstances that could not have been reasonably foreseen, which require immediate attention and possible action by the board, and which of necessity make it impractical to provide notice to members. So there's 2 or 3 requirements in there. The reasonably foreseen one is you can't have an emergency meeting on a budget deficit that you knew you were going to be in at the beginning of the year. But if you all of a sudden you got an insurance notice that your insurance is being canceled, and you've got another insurance that you could replace it with, but you have to answer it tomorrow or whatever, then you could do something with an email emergency meeting, right? Those are like that type of situation. This one, then the next couple of things talk about what you got to do. You don't have to give notice of the time and place if it's an emergency meeting. And again, that could be an in-person one. That doesn't have to be unanimous. Just one board member could call it. But that has to be in a physical location. But then the emergency meeting by email, as we say up here on the screen, if all directors consent in writing to that action. And that's where the play is. Like, we don't know what to that action means, right? What is the action, the emergency meeting itself by email, or is the action that that is being taken at the emergency meeting being consented to in writing? So that's where the play is in the statute. But again, if you guys have a specific issue on that, we can talk about it. Yeah, and then the details. Well, you're asking new manager, well, how do I record that? And you just record it at the next for the next meeting. You record the minutes of that emergency meeting at the next meeting. All right. And then as it says there, otherwise you can't do it by emails. And I know a lot of boards do that. They do, and they shouldn't be, because it says right there in the statute that they shouldn't. And again, the reason for that is transparency. They shouldn't be discussing board business without the members being able to view it or listen to it. That's because we have an Open Meeting Act in California. And if it's violated, guess who can sue? Any member offended by that, or who is not party to that open meeting, can sue. And they get attorney's fees and the civil penalty for $500 for each violation. All right, well, maybe that's the $500 doesn't seem like a big deal, but depends on how many of the meetings you had. And then the attorney's fees can really add up And sometimes insurance may or may not cover that. So you definitely don't want to be doing emails, meetings, nor do you want to be doing meetings without the proper agenda and without the proper notice. Because otherwise it's just more work for us lawyers. Yeah, I was thinking about this the other day. Did you guys know what's even better than a talking dog?
No, what is?
A spelling bee. That's terrible. I apologize for that joke. I won't repeat it. All right. So, what is the point of all this? Well, hopefully, from a manager's perspective, you can say to your complainers that the board can only take action on particular business items during a properly noticed meeting, unless it's an emergency. That you can say that, look, it's not a business, it's a corporation. And it not only is it a corporation, it's a nonprofit mutual benefit corporation. And there are rules and laws that govern it. And those, we can't break those laws. Otherwise, whatever we do can be walked back. If you do things outside of the Open Meeting Act, whatever you've done, it can be overturned by a court later. And so the net of this, and it's to everybody's chagrin, nobody likes this, but it means that it takes time to get things done. Right? Things don't happen overnight, unless of course they're like plumbing emergencies or whatever. It takes a while for things to get addressed. So very often people don't know this. That includes some managers, but not you anymore because you guys are learning it. But it very frequently includes homeowners. They just don't know this stuff. And you would be surprised at that one loud person who's always complaining to you. There's always one. That if you get that person in a room with the rest of the association or most of the association at like a town hall meeting, and you explain what I've just explained to you, that they can't do that business and that it's a corporation and that they have rules and all that, most people are very understanding of that. And that actually will go a long way to alleviating tensions. You may not get that one squeaky wheel fully greased, but you will worry less about that squeaky wheel because you know that everybody else is reasonable and they've heard how business gets done, and that will take the pressure off you from this one kind of squeaky wheel. So if you're having issues and you feel like the owners could benefit from some training, we can do that in addition to our board trainings. And we found it to be very helpful to associations that are having difficulties. All right, so here's the procedure. It's right up here on the screen. So if it's not an emergency, you just do this. You say, I can't talk about it now. It's board business. We can possibly take that up at the next board meeting, the association, and that depends on if the board wants to put it on the agenda, because they're the ones who set the agenda. And then if they do agree, the board says, yeah, we should talk about that. You will put it on the notice. You'll put the pertinent materials in the packet for the board meeting. You hold the board meeting, and then if at least 3 of the 5 of board members are there or a quorum is present to begin the meeting, the majority of that quorum determines the response to the particular issue. And then anybody who wanted to talk about that issue can be there and in the open part of the meeting kind of say what they want to say about it. And then once the board makes their decision, and again, it's another training, but we can talk about that later. You don't have to necessarily consider what they say. You just have to listen to them. But then you provide the response after the board makes the decision and pursuant to whatever authority the board gave you to respond to that homeowner. All right, so that kind of frames it for you. Okay, and so then there's harassing conduct. Then there's just people who are not reasonable or who are harassing you or others in the community, and that's usually an enforcement proceeding under the governing documents. Most governing documents have what a nuisance or harassment policy, where you can say, hey, you know what, that's abusive or harassing, or that's interfering with my use and enjoyment of my separate interests. And you can get the offending person into a disciplinary hearing with the board and address that harassment that way. You can also adopt policies if it's among board members. Sometimes board members can be rude to each other. Sometimes some board members just won't listen. You can adopt a board code of conduct, and that can be a tool to reprimand and or discipline a particular board member, although that does get that kind of tricky. So be sure to contact us if you've got a rogue board member that's causing trouble, because the basics behind that is that they were elected and it's hard to remove them. And there are a lot of legal risks in disciplining them or publishing information about their conduct and things like that. So be careful about that and contact legal if you have a rogue board member. But if you want, we can help you with a board code of conduct policy. All right. Yeah, so this is kind of what I was talking about. If there's a board member that's in trouble, I have one where a board member was caught on video harassing two teenagers walking through the association. He said he was a board member, and he called these young ladies some names, and it got on TikTok. And so the board wants to remove that particular board member, and he's kind of fighting it. So you have to recuse that director. He can't be involved in any decisions regarding his own discipline. But you definitely want counsel to advise the rest of the board, how to proceed. And that involves looking at your bylaws, looking at the laws, looking at the facts, and deciding, which of a series of options are available to you to kind of hopefully correct that board member and put them on notice of things, at least, if not remove them, if it's available. And sometimes it is, sometimes it is. There are a lot of limits on your ability to remove a director. And it's because it's a democracy, and some constituents voted for that individual. And so the remedy would arguably be at the ballot box and not in a board removal. That's for board member misconduct. Did I talk to you guys about the importance of eating dried grapes? It really is about raising awareness. Okay. All right. The Open Meeting Act is your friend or tool. Let's call it a tool. It's a tool. It's not a person, but it's a tool that you can use to help manage in a timely and legal manner the inputs and complaints you're getting from membership. And to summarize, those non-emergency, non-time sensitive issues go on the agenda for the next regular board meeting. And it gets solved then, and then you communicate pursuant to the authority given to you at that board meeting by the board. And that's democracy, due notice, due process, all of that, so that people can hear what's on the agenda and listen. If they want to go, they can go. Other ways to manage those expectations by communicating these facts that we're talking about here, that it's an Open Meeting Act. You can have counsel such as us give homeowner training or board member training to set the expectations for both of them, because sometimes you'll have a rogue board member just firing away and asking questions or doing things that they're not supposed to be doing, and they'll correct their behavior when they're told that what they're doing might subject them to personal liability. So, and that's something we can help out with too. And again, it's part of that special package we got going on. So that's kind of the pre-planned version of the event. I can answer any questions you have. Were there any submitted in advance or no? Can't remember.
I'm not aware of that. I don't know if Melody.
All right. So I don't.
Yeah, I was going to say, we don't usually take pre-questions for our CMU trainings. And we try to, when we do have questions, it's related to the topic. But if you're willing to give us free non-legal advice on other things, we're definitely open to that.
Sure. Okay. Did I stop sharing yet?
Not yet.
Okay. So I'm going to hit this stop presenting thing, and hopefully I don't sign off. Is that what I'm supposed to do?
Correct.
Am I still there? Yes.
Yep.
Okay, super. All right. Nicole Fisher and Sarah Earing have their hands raised. So Nicole, why don't we start with you?
My question, because like Brent, I seen that from not Angus and Terry, but Adam Sterling about the Open Meeting Act and being able to discuss things via email. What recommendations would you provide us for board members that continually, when I say please respond individually, and they continually respond to the whole board, and do you have any tips, advice, any words that you might suggest for me to get them to stop?
Sir, you are being naughty.
I wish.
Let me ask this. When you're asking for an individual response, you're asking for an individual response to like attending the meeting, or what kind of individual response are you asking for?
No. So like for one of my associations, I'm trying to get the homeowners to stop reaching out to the board directly.
Oh yeah.
And facilitate through management, because that's the appropriate chain.
Right.
And so the homeowners go to the board members, and I'm like, hey, we can put this on the agenda for the next meeting. Let me work on this. And they want to continue. It's not a debate. It's not up for conversation. We can discuss it at the next board meeting. So I try to be polite, but it's like, let me do my job.
The board member then replies to the entire board and the homeowner and says,
no, to the entire board, and then to the, and sometimes they go back and forth with the homeowner.
Yeah.
And I'm like, hey, you guys are putting yourself in a liability standpoint here.
Yeah, and some of them won't care. You just want to create the record that says that, Mr. Board Member so-and-so, that your communications with other board members can be construed as a violation of the Open Meetings Act, and it can subject the association to a lawsuit, fines, attorney's fees, and walking back whatever action is taken outside of the board meeting. I would encourage you not to do that. We know you think it's efficient, and we admire your efficiency, but we're just worried about the association's legal liability and yours as an individual director. Because if that individual director is doing things that the other board has not authorized him to do, then that he's acting outside the scope of his authority, and he potentially is personally liable and not within the business judgment rule, etc. So, did we give these guys a board training yet?
I don't believe so. And I recommended that they do the echo training. And I'm not sure if it's one of your clients, but
Sounds familiar. Bryant, HOA, is that what you said?
No. It's actually Reichert in Novato, but
Okay.
I'm not sure if they're in Angus and Terry, but it's just getting them to stop, because they're putting themselves at in
Yeah.
a position that they don't
We
want to
can
be in.
also have, yeah, I mean, you can ask for a code of conduct as well. Code of conduct would prohibit that. You know, it's that
Perfect.
would put in place, you're not supposed to talk to vendors, you're not supposed to talk to homeowners, et cetera. They can still do it, but then you can point to the thing and say, hey, you signed this thing. And that can be the basis for the disciplinary action that I was talking about earlier.
Perfect.
Yeah. So, man, no good deed goes unpunished. Sarah, do you have your hand raised politely?
Yes. So I have a question regarding, first of all, I've been doing this a long time. So I have a tendency to understand that some of my boards or associations will assess risk and determine, how active this community is. Sometimes smaller communities, they let the board just do their thing, get work done.
Right.
So I recognize that. So in this situation, two specific situations, and I came in kind of late. So I don't remember if there's any situation in which the board can do an email vote. If there is, let me give you an example of one. We were supposed to have a meeting. We didn't have quorum, got postponed. Before the next meeting, we were supposed to start this dry rot project that should have been approved. The contractor needs to order the materials, and has been like, I got to get you guys on the schedule. I need to know if it's approved or not. So in that case, we sometimes will do an email vote, only respond back to me, board. We consider it an emergency because we can't wait. Otherwise, they lose this year altogether. They won't be able to start until next spring.
Yeah. So the issue there is, was it reasonably foreseeable that this was going to happen? And it probably is reasonably foreseeable. And especially if you can do like a contract negotiation, you can do on 2 days notice at executive session, right? And the statute's explicit. It says, you cannot do meetings by electronic transmission unless it's an emergency. And in the emergency is as defined, it's got to be, not reasonably anticipated, require immediate attention that obviates, sorry, that's a lawyer word, that makes it not necessary that you give everyone notice, that it's just so impractical that we can't give everyone 2 days notice of this to have it. And it's just, those circumstances are like when death is on the line, or when property damage is imminent, or that like you have it's possible a financial decision could come under that if you're like you're going to lose insurance coverage or something like that. But generally speaking, contract.
Okay, so the answer for
And
me,
again, it has to be unanimous. Like every board member has to say, I agree that we can have this emergency meeting without giving notice to all of our members, any one of whom can get pissed off that they weren't part of this thing and say, you know what, you violated the Open Meeting Act. I'm suing you. You're paying $500 for every violation. You're paying my attorney's fees. And that decision that you hired that contractor is going to get set back, and we're going to start over.
Okay, so the takeaway answer is, if you have time, do a 2-day. I can do a 2-day meeting.
Yeah, for if it's an executive session to consider the formation of a contract and the signing of a contract, that can be done on 2 days' notice.
Okay, so do a special executive session. Yeah. Okay,
and then we need a quorum too for that. You don't need all 5. You don't need it unanimous.
That's a whole nother discussion with this board, because if one specific board member isn't there or can't make it, this board won't make a decision. Yeah. Which is the other reason why we utilize the email when it comes to this type of stuff, because if this one particular board member isn't there, the rest of the board won't move.
You see that sign behind me? You probably can't read it because it's backward.
No.
It says litigator, right? Because that's what I did before I did the homeowner stuff. And my litigator mind is email transactions are never going away, and they are evidence of what's happened, right? They are admissible evidence, and they are and so all you're doing is creating a record for some disgruntled homeowner to take it and say, you violated the Open Meetings Act, my rights were denied.
Mhm.
Um,
Okay,
once-
so moving on, got that. I'll let them know we're not gonna do that anymore.
Okay.
Second part of this is same situation with, we didn't have quorum, so we had to postpone the meeting. A homeowner in between that time, before our August meeting got canceled, was concerned about speeding within the community because they've been subject to almost being hit by a vehicle. Said, I'll forward your email to the board, we'll put it on the agenda, they'll discuss it. We didn't have quorum, so she just sent a follow-up email. Our meeting is next Thursday, saying what's going on. I haven't had an update. I was planning on attending the meeting, but it was postponed. I said, correct. So they'll discuss it this meeting. She's like, this is a life safety matter. My husband almost got hit again. We're not going to tolerate this. We're contacting our attorney. I said, look, there's certain requirements. So they are discussing it at the meeting. It is on the agenda. Is that a true life safety issue?
I don't, the kind of life safety issue, like unless you're on notice that this happens every day and is
Right.
likely to happen tomorrow, I don't know that it's for that kind of emergency that you need to forego notice to everybody who wants to talk about it. How far away is the meeting?
Next Thursday. So she
Yeah.
emailed us yesterday. When she emailed us, it was 8 days from the next meeting. So.
Yeah. So it's unlikely to be that the kind of emergency I'm thinking about is like the pool is going to burst open and destroy all the cars underneath unless we get.
Absolutely. And that's my, my manager hat response to her is just that, but at the other thought, I don't want her thinking that I'm dismissing her concerns for human life, as she says.
Sure. Yeah. If you're on notice that they're going to do a street sideshow or something on your community property tomorrow or something like that, then you can have the emergency meeting by email. But really, the one or two incidents probably doesn't amount to a life or death emergency situation.
Yeah. And we don't get, at least it doesn't get to us. She says the community's talking, but it doesn't get to us that people are in uproar or a lot of people are complaining about how people speed through the community. Part of which I explained in my response was the board, there's a lot to discuss. I know some people just think install a speed bump because that's what she wants. She wants speed bumps. Install a speed bump. And I'm like, well, I've been in situations where, yeah, the board makes a decision installing a speed bump. It's fairly easy. And I've been in other situations where we actually get a whole traffic study because no one wants to be responsible for the impact that speed bumps cause to surrounding homes.
Right.
So
sure.
It's not as easy.
You're not gonna what's the action you're gonna take? Exactly. We're not gonna get a speed bump put in
installed tomorrow.
Yeah. So
okay. All right. That was it.
Good questions, Sarah. Thank you.
Thank you.
Anybody else? All right. Well, I'm happy to share this time with you.
Thank you so much.
You're welcome. Hopefully it was not boring. I try to keep it light, as you know.
With all those jokes, Colin, it can't be boring. Come on.
Yeah, I'm working on my material. Sometimes I
I
forget.
have some new ones to share with my 5-year-old great nephew.
Yeah, exactly. These are the kind you can definitely take home. If we have a couple of drinks, I can tell you ones that you can't take home. But that's not a typical work event. That's just friends talking.
I always thought they said lawyer jokes were bad, but I think it's the other way around. Lawyers are bad at telling jokes. No,
Yeah.
I'm joking. I'm joking.
Hey,
Ouch, Lori.
I know,
Ouch.
I'm sorry.
Lori, you just reminded me of another joke.
Okay,
All right?
good.
Get ready. Why do lawyers not laugh at lawyer jokes?
Why?
Because they're
Why?
not funny. You're right. It is
We
all
have that
about-
on the recording.
It's about delivery. It's not delivery, and it is an art form, and I do try and work on that art form.
I appreciate your jokes, Colin. They are very funny. It was just something that popped into my head when you mentioned your couple of the jokes, and I thought I had to
I
share it.
resemble that remark. Definitely. I definitely do. So, all right. Well, thanks so much for your time, everyone.
Thank you.
And, let us know if we can help. We're here.
Thanks, Colin. Appreciate it.
No
Thank
problem.
you.
Thank you. Bye.
Thanks. Bye.
Bye, everyone.